Hi, Joseph. Oh.
No, that's me.
I mistook that for you. It looks so much like you.
Shout out to Max. That's very adorable. Thank you for getting me a cuckoo pop.
Funko.
You pop?
Funko.
Me pop? It's adorable. Can we zoom in?
That's amazing.
Thank you so much. I love when I get this thing. First of all, it has a lot more hair than I do, but I'm dressed like Donald Trump in this. It's a red tie, royal blue suit, but it's appropriate. It's got black shoes. So thank you. That's very kind of you.
Yeah, the shoes.
I love it.
What socks though?
Dark.
Okay, that's important. I've seen you make that very important.
It's so basic. Matching socks to your suit. It has to match the color. Like there's no way around it.
You're an expert at that.
Right? Not that hard.
So we actually have a very serious topic though today. We want to talk about it's going to get a little bit technical, but we want to start out with a little bit of an overview of what we're going to talk about. So evidence, this is a big thing. We want to talk about the top 5 things you need to know about authenticating evidence in court. And so what we're going to do, actually, instead of the top 5 things, I guess we're kind of looking at the top 5 types of evidence, right? Yeah,
so this is really a great idea. And we've had...
It's your idea, so, you know.
Well, it's actually not totally borne out for me.
It is a good idea.
Because we've had... Again, like a shout out to everybody who watches the podcast and the excellent comments and in questions. And one of the areas of questioning when we did the last episode on the JJRD type of cases, and somebody made, a good comment to say, we talk often about evidence and we were mixing up in their mind testimonial evidence versus other evidence. And they were right, and then asking about what other evidence and then how does a diary corroborate the testimony of a complainant, blah, blah.
Or can you use a diary even?
Right.
That's what we're going to talk about.
So it was an excellent idea, which got me thinking that, we really need to explore what other evidence is available. And we can talk about documentary evidence and electronic evidence. How is it authenticated? Therefore, to become admissible, and how do you combat it?
Right, so the 5 main types of evidence we're going to talk about is text messages or other text-based kind of things like through social media.
Electronic communications.
Videos and audio recordings. Hard documents like, say, a gift somebody gave you or a diary that comes into your possession. Court documents from other, procedures you might be going through in court.
That is vintage water.
And it is very good. And previous police reports that may have occurred during your interactions with this person.
Right. So those are what we call in the business occurrence reports, where on a previous occasion there could have been an altercation or some sort of complaint. Police make a report. An
incident report.
And it's called an occurrence report, and that comes up quite often. So
yes. These are different types of evidence that have different aspects to them. And there's certain things about admissibility that are going to get a little bit technical, but it's really important because a lot of people who come to us, they think, oh my God, my case is like, so easy because I've got this, and this, and they need to understand the rules of evidence. And then also the converse side in terms of what a complainant can provide to the police and what could be used against them in court, and how those rules of evidence differ between when a complainant and the police have possession of it versus when an accused person has possession of it.
Yep, 100%.
So
where do you want to start?
Well, let's start out with, one technical thing. There's a difference between evidence in your possession and evidence that you want to obtain through a third-party records application. Just to be clear that, sometimes you think something is out there that you want, and, sometimes people think that a complainant's phone can be seized and searched. In Canada, that's not the case. They never do that. And you have to bring an application if you don't actually possess the records, but you're looking for them. And it's sometimes called a fishing expedition. You have to prove that you're not fishing. You have to prove that you know what you're looking for.
Okay, so let's, for example, use the common type of record that some people may go after, which is a therapeutic set of records or counseling records. So an accused might want to obtain records from joint therapy sessions with their ex-wife where they were in counseling and certain things were said that they believe could contradict her evidence. Those records are in the possession of a therapist. They're medical therapeutic records. You have to bring a special type of application in order to get access to them. You have to issue a subpoena and then bring a notice of application in factum as to why it's relevant. And
you have to somewhat know why you think it's going to be relevant. That's not
you
going
have
to be
to identify
cast
what
as
would
a
be
fishing
relevant.
expedition.
That's right. So that's a complex type of application. We call them Mills applications under the case law. But what we're trying to talk about right now are 5 sources of evidence other than testimonial evidence that an accused may face in a trial, and how do you deal with that evidence?
And these are records now that we're talking about in your possession. So let's look at first a very, very common thing in our era: text messages, be it via actual texting or WeChat, WhatsApp, Instagram messaging.
Yeah, so let's lump it as electronic communications that can consist of things that we don't use, like Instagram, Telegram, all those communication apps, as well as traditional text messaging, etc. So those electronic communications are very common in criminal cases where a complainant will then take a selective array of messages. They'll do screenshots.
Do a few screenshots.
And they'll provide it to the police as they see fit. It is not a complete thread. They're under no obligation to provide a complete thread. The police, as you said very aptly, will not seize the phone of the complainant to do an extraction. They will simply rely upon the complainant to provide what messages they want to provide that they think is relevant.
And we've kind of kvetched about this a little bit before. I love that word.
Kvetched?
Yeah.
Good one.
That sometimes the police don't even obtain those messages themselves. They actually just ask the complainant to provide them with things. So the authentication,
Yeah.
and that's what we're focusing on. How do you authenticate those messages? And does the Crown have to authenticate text messages when they're obtained from the complainant?
Okay, so, commonly with messages, even videos and audio recordings and pictures, for example, these are items of evidence that can be authenticated primarily through the complainant's testimony. So they can provide the messages and they can be authenticated by the providers. So if the complainant is the recipient of these messages or the author of these messages, or they have taken the pictures or the video, they can authenticate the messages, videos, and pictures by their testimony. Right. Do you want to elaborate?
Well, there may be some dispute from the accused if there's missing messages.
Let's first talk about authentication and then how you dispute it. So I think it's helpful because I don't want people to get confused, because you raised an excellent point. We will often have clients to say, but that's not real. Mm-hmm. How's that admissible? Well, guess what? The threshold's pretty f***ing low.
It is. It's a low threshold, and that works in the favor of the accused person when they want to use their own messages as well.
Good point.
Right? So, but there's sometimes a lot of, dispute over whether they're complete, and then sometimes people will say, I didn't actually send that message, this is faked. Because it is possible to get a screenshot where you can send yourself a message and then just call the person something, put somebody else's name on it and make it look like that person sent you a message. Mm-hmm. So this is an interesting factor in terms of, when you want to challenge, and you can challenge the authenticity of it. And, generally with text messages, we would then show that this person's name is this specific phone number. And it can be challenged even further to the point you need an expert.
Okay, so let me just go back to how you authenticate digital recordings. Pause. Okay. Under Section 31.1 of the Canadian Evidence Act, any person seeking to admit an electronic document as evidence has the burden of proving its authenticity. To meet this burden, the party may adduce evidence capable of supporting a finding of what the document purports to be. Okay, it sounds a little legal, but again, testimony can establish its authenticity and what it is meant to reflect. So
like,
this
like
means,
we say often, like testimony is giving evidence, so that when
Correct.
you're testifying, you're actually giving evidence. Yes, this was me, and this was that person. So that is one form of authenticating.
Authenticity, yeah.
It was like authenticity, authenticating a specific document, is the person can just say, yeah, that was me, and that's what I received from this particular
So let's
person.
define that. So authentication can be proven in a number of ways. One, direct evidence in the form of oral testimony of the author of the document. Two, what you mentioned is expert evidence and circumstantial evidence. So this is three very easy ways for, let's say, the Crown, because we're dealing in criminal cases, to authenticate a document. So, one, you can have the complainant testify that this was a message that I authored, or a picture I took, or a video I took, or this was a message I received from the accused. Here's why. Or they can be faced with a document, such as a message, and say, this is a message that I believe I received. Here's why. It has content that is similar to what the accused would have sent me. Mm-hmm. This was the language they used. This was content that was about our relationship that he or she would not have ordinarily known. Circumstantial evidence proving its authenticity.
And there can be timestamps on the messages. Sometimes we get screenshots of messages with no actual timestamp. Those are a little more problematic. But when it's got a timestamp on it and that aligns with an event that is known to have taken place, that would tend to make it more authentic.
Good point. So a lot of the time we will get messages, or what will be tendered in court will be messages that will have a date on it. And then we can obtain the metadata from the Crown, but you can explain metadata better, because that will change from the time that a person will then download it and then transmit it, and then it'll be downloaded by the police officer and then transmitted to the Crown. So metadata can change, and that happens to us too. We can get it sent to us, we save it, and then we relay it to the Crown. The metadata can change, but you can trace that. And so having messages that will have a date on it, sometimes pictures will have the date on it, that will help with its authentication, and then the metadata will also help as well.
Yeah. I mean, there's certain factors that can be brought up in terms of why you're challenging the authenticity, which can then require you to go to an expert. But in most of our cases, we don't actually require an expert.
I agree. So let's just talk for a moment about how high is this threshold? Because people will ask us, so really, in order to prove these messages, isn't it a really high threshold to establish that? That's the question that will get asked. Mm-hmm. No. It is a low evidentiary threshold requiring only some evidence that the document is what it purports to be. And that is according to the case law. So, for example, it goes way back in time. Her Majesty the Queen versus CB, and Regina versus Donald, and this goes back to 1958 and continues on from there. And our very well known and liked jurist Justice Pachaco has written about this. So, in other words, the requirement is not an onerous one and may be established by direct or circumstantial evidence. It's a low threshold. I want to be clear about this. Authentication of these digital communications is a very low threshold. It's not a high one. Then issues with respect to whether it is truly purporting to what it will be after it's admissible can go to its weight. In other words, what relevance and impact it has on the trier of fact will be determined at trial. And that can be challenged in cross-examination and submissions, also through testimony of the accused. But I want to be clear, the threshold for admissibility is low.
Mm-hmm. But, you know, what you mentioned is important too, is like, and that becomes the biggest thing. Even if something is admissible, even though it may not be completely authentic, it may be admitted, but then it goes to weight.
Okay, so let's be careful. Let's be careful. Yeah. So this is language of a lay person, and this is where we get legal. Evidence can be authenticated even where there is a contest as to whether it purports to be what it is supposed to be. So let's be clear. It will be authenticated quite easily on this threshold. It's authenticated. But you can still challenge it as to not reflecting what it's said to actually be. And there are many ways to attack that. But let's be clear. The authentication and admissibility is a low threshold.
Mm-hmm. And so that, again, is true for both sides. So the Crown, Crown bringing in complainants' text messages, we're saying, well, these are out of context or not complete or whatever. Same thing can be said for an accused evidence where they want to bring in certain text messages, and then they have to be put to the complainant, who can then say, well, that's a partial message. So the same thing is true on both sides.
Correct. So let's go down to basics. So messages that are to be tendered through the Crown or the defense have the same burden of proof. Thank God. What's good for the goose is good for the gander. Okay? Now, after its reception into evidence, it's a question of fact to be determined by the judge as to whether or not it is what it is. And that's what Diana's talking about. Like, you're talking about how we deal with it in evidence and how we can attack it, and then the judge will have to determine as a matter of fact what it is and what it purports to be,
whether
and
it's
then what its impact is.
Well, there's a fulsome record of what was occurring at the time, or whether it's something that's cherry-picked and edited.
Okay.
Right? So, you know, a second thing is like videos and audio recordings. And I know it's a big thing online when people are concerned about being charged with stuff they didn't do in domestic violence and sexual assault or whatever. They said always be recording. You know, videos don't always necessarily work for you. And in fact, they can result in an extra charge if they're surreptitiously recorded of intimate encounters. But we've also had a number of cases with audio recordings as well. And a lot of these are surreptitious when they're brought into court. There's, you know, recordings being made without the other person's knowledge. So surreptitious recordings do draw some suspicion. And then there's always the question, when you know you're recording but the other person doesn't, did you choose that moment to start the recording? And then did you cut it off when it was convenient for you?
Okay.
So those are going to be issues that are looked at in terms of the recording.
So authentication of a digital recording. So let's talk about an audio recording or a video recording. Requires the tendering party to authenticate the integrity of the system storing the digital record. This can be proven on a balance of probabilities, more likely than not, that the device storing or recording the digital record did not alter, distort, or manipulate the digital record to affect the integrity of its contents. Pause. So, a lot of the time when we're faced with a picture or an audio recording, we don't even go that far because we can tell from the actual record itself, it's probably accurate.
You can see the person, you can hear their voice, you can kind of decide, like, you know, and generally people will authenticate, yeah, that's my voice, but they may dispute the context of what the recording was.
But as a matter of law, when you're dealing with digital recordings, audio, video, it again is on the person tendering it. So if it's the Crown in our case, can be proven through the evidence of a complainant, but it has to be proven that how was it recorded? What was it recorded on? Can they establish that it was not altered or distorted or manipulated in any way?
We should actually pause to point out that we're talking about Canadian law, and you can one-party record in Canada, whereas like some of our audience may be in the States, and so it depends on the state you're in, whether or not you're actually permitted to record. Yep,
in Canada, so a recording of a conversation, let's say Diana and I are having a conversation, I can surreptitiously record it, it's one-way consent. But let's just ask this question. What does this mean in a case? So do you really have to establish its integrity? Well, the Canada Evidence Act helps. Section 31.3 says, the integrity of an electronic document and its system is presumed when there is evidence capable of supporting a finding that at all material times the computer system was operating properly, or if it was not, that this did not affect the integrity of the document and there's no other reasonable grounds to doubt the integrity of the system. So this helps a Crown, or if you're in a civil case, prove the integrity of the system for recording. So you can say, I had my phone on, my phone's properly operating, there's no issue with my phone, I had it on record, and we were talking. And you can hear from it very clearly the dialogue. You're done. It's no problem. That will be admissible. We will talk about other issues about how to deal with that and what other flaws there may exist. But it's pretty simple again. It's a low threshold.
You can recognize the voices. You can recognize if it's a video, you know, the images of the people involved. But there are some problems where you can see sometimes that it appears a video or audio recording is edited. So you can see a jump in it, right? And then that becomes suspicious. Or we've had cases where there was an audio recording of one specific conversation cut into 3 or 4 different pieces. So then you have to ask yourself, what did they cut out between those different things? So editing of an audio or video image can make it very concerning in terms of the authenticity or the integrity. Not authenticity so much, but the integrity of the recording.
That's the point. So what I'm reading from is actually our own internal memo on this. So that's right. It's not about its authenticity, it's about its integrity. So Justice Pachaco stated that if a witness provides evidence that an email or image or recording was received on a device that functions as a computer, or that a text or tweet was received on a phone, this is circumstantial evidence that the computer system or other similar device that sent or received the images or messages were operating properly. Again, a low threshold. Canada Evidence Act helps you, and the case law helps you. And so what you're talking about is how do we deal with the integrity of it and what weight to attach to it. But again, the threshold is not very high to get it to be admitted.
In terms of authenticity and admissibility.
That's right.
Yeah.
And that's what people mix up. We have to be careful about that.
Yeah. So, but the integrity and the weight to be placed on it will be dependent on the quality of the recording and whether or not it appears to have been intentionally manipulated in terms of the start time, the end time, and if it looks complete. If something starts midway through a recording, then it's more apparent that something was cut off from the beginning.
But that would not impact its admissibility.
Exactly. So it's still, you know, can be authenticated to some degree, but you're only authenticating that this was a partial recording.
So let's just, there's a case called Bulldog. I love that name.
It is a great name.
Yeah, Court of Appeal said that matters for videos and photos is the accuracy of the representation of the event. The onus lies with the party presenting the video or photo to satisfy admissibility requirements. The accuracy is truly representing the facts, fairness and absence to mislead, the verification on oath by a person capable of doing so. Again, f***ing low threshold, okay? Very low threshold. So I just want to repeat this and circle back, and then I think it's very important for us to talk about how do we combat that, because you've raised good issues as to how we can be skeptical. Well, we want to help each other here and make us feel good. So I think this is really important because this question arises a lot. And that's why you and I wanted to talk about this. Mm-hmm. Threshold's low. It's not that it's insignificant because, you know, you can imagine circumstances in which a witness testifies to say, well, I've got this message, but like it wasn't recorded on my phone. I got it. Somebody gave it to me and I have it. And like, I think this is what it is. Like, that's not good. I sound like a Valley person.
So your university voice, I think.
You know what I'm totally thinking about? There's that skit in SNL from a long time ago with Bill Hader. They were like what was it, California? Like I took... No, it was like, I took Highway 48. It was just f***ing hilarious. I got to think about it. But like the threshold's not that high, but there are instances where it will not be admitted because the witness testifying as to what the actual document, video, or electronic evidence is cannot really attest to its authenticity. So you can battle it on that basis, and that's not, you know, a given that it will automatically go in. But I'm just letting everybody know, in law, it's not a high threshold.
Right.
So let's talk about, because we love these listicles, you know,
so
top 5 or 6 ways to combat that. But what's your number 3?
So number 3 is like hard documents. Typically, one of the main ones we've seen is like diaries, right? a diary or a gift. We had a case we talked about with a tattoo book that was given as a gift with an inscription in it. And so these are like hard documents in your possession that have legitimately come to your possession. And whether or not, you need to authenticate, especially if there's something handwritten. There was actually an interesting case where a young girl wrote some sort of a letter and then threw it in the trash, and her parents pulled it out of the trash, but the trash hadn't gone out to the curb yet. And then they talked about whether or not it legitimately came to their possession. So sometimes you come across hard copy documents that you want to submit, like a letter that was written to you. We had a great case actually with a great big anniversary letter that was written saying all the good things, that the person remembered about their relationship, and went on about a lot of personal details. And this was a gift to the person. So you can come across these documents too. And then
they're easy to authenticate.
Yes, but sometimes there's a question of, whose handwriting is that? Do we need to worry about authenticating handwriting?
So in 90% of the time, if you're given a gift by somebody and there's an inscription in it or a letter, you can authenticate that through saying that's their writing. Here's the content, which is circumstantially supportive of its authenticity. It's content about their relationship. It's content about facts that the two of them would have only known. Therefore, you can prove its authenticity through the circumstantial evidence of its content.
I
Pretty
think in
easy.
general too is like, you basically, if you can testify as to when you received it, why you received it, and who you received it from.
Or if you're the author, let's say it's the flip side. You're testifying on behalf of the Crown. You have a diary like we spoke about in the previous episode that was in JJRD. And you say, yes, I've been chronicling the abuse. That was for the last 5-6 years. Here's what I wrote. Here's the dates I wrote. That's good enough for it to be admissible. Mm-hmm. It can't be used necessarily as a prior consistent statement, but it can be used to rebut recent fabrication and has other collateral sort of supports. But you can testify as to its accuracy.
Because you said prior consistent statements, it just means just because you said something before doesn't make it more or less likely to be true, because somebody can lie multiple times.
Right.
But and also people can try to fabricate documents in order to bolster their claims at a later point, right? So that's why, something isn't admissible as a prior consistent statement, but the fact they said it at a certain time may be admissible for other reasons.
Correct, because you can have instances where somebody actually manufactured evidence to try and support their in-court testimony.
Right.
So we have the rule that if it is written in a diary, it's not a prior consistent statement that can be used to bolster the credibility of the complainant about the allegations themselves. But circumstantially, it can support the credibility of the complainant
when they said it.
Of when they said it, rebutting a recent fabrication. Complex, but we spoke about that before. Mm-hmm. I don't want to go down that rabbit hole right now because we just want to talk about authentication and how to deal with it. So hard copy documents like diaries, letters, etc., the author of that, let's say it's the complainant, can testify as to authenticity, when they wrote it, why they wrote it, etc. And that can prove it and it can become admissible.
Mm-hmm. And primarily what you're looking for authentication and to have it given more weight in court than less weight would be your ability to testify in some detail about how you received it, how you got it, and what the circumstances were.
Yeah, so let's take an example because we had the tattoo book.
Right.
I was out for my birthday with my girlfriend. I was interested in tattoos and I was about to get a tattoo, and she bought me a book about tattoos, and it was very interesting and had meaning to me because I was interested in these things, and here's what she wrote in the book. And it writes, "Dear X, blah, 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 love X." Well, you can pretty much authenticate it that way.
Right. Yeah. And the timing and the age of the book and everything was all aligned with the facts of the case. Correct. And this was in rebuttal to a claim from that individual who gave the gift saying that there was no actual personal communication with this person at the time.
Right. So we used
the relevance was quite high.
Yeah. Well, that was a fucking walk in the park. So that was great because the complainant in that case had said, I had no relationship with him.
Yeah. He asked me.
Barely knew the guy.
He asked me out and I turned him down and I hardly knew him at all.
And here enough, he kept for 20 years a book that she gave him as a gift with a very lovely inscription. So that was great. Let's talk about court documents.
Right. So this one gets more complicated, and I'm gonna, I've actually
Not that complicated, but go ahead.
Well, no, but we had a case too where it's like we're putting in documents, for pretrial applications and such, and then there were some things which, then you end up saying, yeah, we're actually not allowed to use those. So there's some court documents that people may be engaged in that are mediation.
Documents related to mediation and settlement documents. So if you're back and forth on a settlement, it's litigation privilege or settlement privilege, not admissible. But let's talk about typically what we deal with in family court. Documents where people are divorcing each other, and they file an application for divorce or reply, admissible. Affidavits, admissible. Case conferences, admissible. Motions and affidavits, admissible. It's all f***ing court documents. It's public. There's one judge recently in Ontario who said, well, I think it's a third-party record. They're wrong in law, wrong in law, wrong in law. Yeah. These are court documents filed in court. They're public records. They're not under seal. They are not records contemplated under the criminal code or the JJ regime. They're not records.
When you file something in open court, then it's a public record.
It's a matter of public record.
Yeah,
and I want to be very careful about this. It is not, if you file a reply or an application in family court attesting to all these issues, including the allegations in your case, that's f***ing admissible. Mm-hmm. That is not that's not a record that could be excluded.
And you're saying that in terms of somebody who's been accused of something, when they, find themselves compelled to file something in family court for other reasons, for access to their children or whatever.
No. So we deal with a lot of high conflict divorce cases, and then there's an allegation of abuse or sexual assault, etc. So the parties are in a divorce. They filed, somebody asked for a divorce. That's their petition for divorce or their application to divorce. The other one, who's the respondent, filed a reply. In there, they cite shit about each other, okay?
Yeah, and you can pretty much put whatever you want to.
You put whatever you want in there. Court. But a lot of the time, if they're making an allegation, the shit's in there, okay? And we want to rely upon that. And then often there's a motion for access to children. And then they put in an affidavit and they talk about abuse and all sorts of other stuff. These are documents of a public record.
Right.
So we can use them without bringing an application. Its authentication is pretty easy. It's filed in court, it's signed and dated, and there's a lawyer's name on it. It's not an issue. But I want to be clear to those who think that somehow this is a record you need permission from the court. It is not. It's wrong in law to suggest that.
Where I was trying to go too is that for an accused person who's facing family court and also being accused in criminal court, they need to be very careful about what they put into their family court documents, because that's also a record of a statement.
Excellent point. Yeah. So if you are accused of offenses from your soon-to-be ex-spouse and you're in family court, you want to be careful about what you put in your court documents. Often we will work with the family lawyer as to what should and should not be said, because that is something we understand very clearly that they can be cross-examined on.
Right. So it works both ways, again, like we've talked
100%.
about with all this evidence. Is
100%.
Both sides. So, yeah, but it is important for people to realize, too, if they go into mediation and they have all these documents being filed for mediation, that those are actually privileged documents they can't just bring in to use in their defense in court.
Occurrence reports.
So, yeah. Well, the court documents from family mediation things, right?
Well, we said if it's mediation or settlement documents, it's not admissible.
So our fifth one is previous police reports, and this has come up a number of times because quite often, especially in these domestic suits, that they've been married for a number of years, and then sometimes police have been called, and there's an incident report from a previous incident where charges may have been laid or may not have been laid. And so sometimes we've had people say, well, oh, the police showed up and they didn't charge me, and therefore it's proof I'm innocent. Mm-hmm. Right? So in terms of how you can use those, it's not necessarily authentication, because these are police reports that are sometimes provided through disclosure, right? But, we could talk about whether or not these are actually proof of innocence.
Okay, so let's take a concrete example. A husband is charged with a number of historic allegations of abuse. The police have been called on 3 occasions. On 3 occasions, the complainant had spoken to police and said, no, we had a verbal argument, there was no physical assault, and there has been no threats. and then the police make a finding that there's no criminal activity. And you've got 3 incident reports, occurrence reports, and there is reduced in writing statements made by the complainant that they were asked, was there any prior violence? Was there any violence? No, there was not. Okay? We get those occurrence reports through disclosure. What do you do with that? Well, one, you can cross-examine the complainant on it. And if the complainant adopts what's said in the occurrence report, you can then rely upon it, and it's authenticated per se. The complainant says, no, I didn't say that.
Well, we've had that happen too, actually, where there was a police report where the it actually came up mid-trial. We didn't even know about that police report that was made.
Yeah.
And then the police report didn't say anything at all, like what the complainant was claiming. So, I mean, that's kind of interesting too, is like, so what do you do for authenticating a police report when this is
You have
actually...
to call the cop.
When you have to call the officer to testify as to whether or not they recall.
So let's be clear. On an occurrence report, you can cross-examine the complainant. If the complainant adopts the content of that report, it's proven, you can rely on it. If the complainant says, no, that's absolutely not true, that's not what I said, you're stuck. Your choices are then to try and subpoena the officers to testify as to that incident and what they took as information, and then you can prove the document through that way and improve the actual statements of the complainant. You can also try, if it's a situation where the husband was part of that interview with police, can also establish the accuracy of the report. Sometimes the judge will be a little bit more lax, and you can try and get the report in as a business document without specifically calling the police officer, and then you can try and rely on it in that regard. But that's a lot harder.
Mm-hmm. But I think the main point to make is that just because police have attended and then a person didn't get arrested doesn't mean that that's proof of their innocence. And a lot of people think that is. Oh, well, clearly they lied because I didn't get arrested. And that's not necessarily the case.
Well, that's for obvious reasons. So let's deal with that just in a more holistic way. So there's many reasons why a complainant may not have said to police in a domestic situation on prior occasions that their husband or their spouse had done something wrong. Any number of reasons. They want to sustain the marriage. They want to protect the family environment, including the children. They don't want their husband to go to jail. Things got out of hand and they just didn't want it to get to that stage. I mean, there's lots of
police,
it.
even.
Yeah, all sorts of things, cultural issues, everything else. So, as much as you may think it's a smoking gun, it's not necessarily a smoking gun. That can be an important piece of evidence cumulatively with a lot of other evidence to assist.
We actually had a case too where there was a prior police report where they actually warned the complainant because they saw a video from that specific event that showed that the complainant was not telling them the truth, according to the police report. But at the same time, the complainant was not charged with lying to police and there was no conviction or anything like that. So it appears from the report that the complainant was not being honest. But even given that extreme kind of a report, it's still not authenticated evidence of a lie.
Correct.
So it's just something you can use to cross-examine, but
it's one of those arrows in your quiver. It may work, it may not work. It's good to have, and if you're judge alone or jury, they hear the report. If it's a jury, they typically believe what the police write down is accurate. So even though you can't prove it, the jury will go in the back of their heads. They're like, "What the f?" They'll think about it.
Police to lie about it.
Yeah, they'll think about it, and then you can, and it's all in cross-examination. You break it down. You spend a lot of time on it because there's words that the complainant will use which will be similar to the content of their complaint. There's just ways to do it. So even though you may not be able to prove that what was said in the occurrence report the complainant accepts, you can really use it as a prior and consistent statement if you're careful and methodical about it.
Now I'm just thinking in terms of, because we mentioned experts too, and experts, to authenticate, videos or images or whatever, it's not usually required, but sometimes they are required. And we just recently had a situation where somebody's computer was deleted and images had to be recovered, messages had to be recovered. And in that case, an expert actually goes in and if required, they can authenticate what the data was on the images that they pulled back out of the computer.
Okay, so let's say this for the Crown and for the defense. So often in certain cases, the Crown will the police will seize the phone of the accused. It'll go through a extraction forensic review with the police. Once they get that information, the police are the ones who testify as to the extraction. So they are experts. There are people in the extraction recovery science area where they will testify to that, and we do the same. If we have a client who's deleted stuff, we recover it, we produce the extraction.
Or somebody else deleted it.
Or somebody else did, that's true. We can have our expert do an extraction. We send the actual report to the Crown, ask them if they want us to call our expert. Often they don't.
I know. Usually, it's it's good to have it there in case required, because we have had challenges.
I think it's very important.
We have had challenges before too, authenticity of documents.
Well, we had one recently where the Crown was asking for the metadata and stuff, and we were able to provide it. Mm-hmm. And it just provides.
And like you mentioned earlier too, is that sometimes the metadata, like when people receive disclosure, then they've looked at it and said, oh well, the date on this isn't, it doesn't look right, but it could just be because police received it and then saved it somewhere else, and then just like we receive stuff and then sometimes we need to compress files, or just uploading it to different places can change the date of it'll have a modified date. But that doesn't mean it's not authentic.
Right. And the beauty about when we are recovering messages or photos or videos from an accused phone or electronic device, these extraction reports and the expert evidence of our people will be able to show date created, date modified, date extracted, etc. So we can cover that. So we're not done, okay? Let's just summarize for a second. So again, when it comes to electronic documents and evidence, the best evidence rule presumes the integrity of that electronic document and sets a low bar for admissibility. The low bar will be met where a party seeking to adduce evidence testifies to its accuracy, such as an audio recording accurately reflects what is spoken to or heard, or text messages of what was said and meant. And so that is generally, the way they get at it. Let's pause for just a couple of minutes to talk about 4 or 5 ways to deal with this evidence from a defense standpoint. Okay? So, how do you challenge digital evidence? One of the things you can do is challenge the weight of what is to be afforded to the evidence. And that's something for the trier of fact to decide. So, again, one of our famous jurists, Justice Pachaco, explains that it's important to identify the purpose of the document. Even though it's authenticated, does it necessarily mean that the document is genuine or purports to be what it is? And so you can go into details about the actual piece of evidence and why it's not that important or does not reflect what the other side is saying.
Or like you said, purports to be what it is. You could actually say, well, it's, I'm clearly not the same age as what I'm supposed to have been in this recording because I look different or whatever. It's like, there could be aspects of it to actually, like, they're claiming it to be of a certain time frame or a certain location or something like that. And you could actually point out things that actually show that it's not what the video purports to be. It could be staged in a different time and location.
Good. And let's talk about metadata for a second. You can challenge metadata. So whether digital evidence has been stripped of its internal structure is an issue. So we can ask for the metadata. And if they're not able to produce it, we can talk about and challenge whether that internal structure has been stripped away. And that can go to weight. The document will be admitted, period. But we can say, since they can't provide the metadata, it has far less weight, far less relevance. In other words, the judge should not be relying on it.
And also, we get a number of surveillance recordings too where the timestamps aren't correct.
Good point.
So that can become an issue too, because sometimes something can come down
timestamps and dates.
A critical issue of the precise minute point.
Now, let's talk about the source of the digital image. So sometimes we'll face, in a case, pictures. Well, who took the picture? What was the source of the creation of that actual image? If it's unknown, that's an excellent way of challenging its admissibility and its weight. Mm-hmm. So
it could be from a totally different time, a totally different situation. It could be staged. If you don't,
exactly.
Yeah.
So we can have a complaint to say, this was a photo taken of my entry back in 2018. Well, who took the photo? I don't remember, one of my friends. That's a problem. Seems simple, and it's effective. What about the quality of the photo or the video?
Yeah, well, quality can be an issue too, especially.
We have a murder case coming up.
Yeah. It's my first one.
I've been through a lot of murder cases. So here's an interesting thing. There's a series of videos from CCTV cameras in the area and from people's homes. And without giving more away, this is not unusual in murder cases and other cases, because in you know, across the GTA and other places, we've got a lot of cameras everywhere. Buildings, offices, everywhere.
People with cell phones.
Everything. But so in these videos, it doesn't necessarily purport what the Crown says it is, because you see the image from far away, you can't tell the height, can't really tell the clothing of what the person's wearing. It's a little grainy. Even if you enhance it, it's not really showing what the Crown says it is.
The more you enhance it, the grainier it gets.
Right. So there can be a lot of issues about the pixelation or the blurriness of the actual images, which will then take away from its reliability and weight. And that's something you've got to pay a lot of attention to, because once you look at it, it's important. And then also here's something else which is important. You can get a series of images from Crown and Disclosure, which will be a compilation video. In other words, they will take it from 20 different sources and put it in a compilation. Do not rely on that. Say, thank you. Can I have the individual sources of these images or videos and provide that to me? Because the compilation can then be very distorting as to what it purports to be. Get the original source, get the original images, and then you can do your own analysis and you can challenge it on that basis.
Now, to be fair to the subject, though, those videos are authentically recorded. They're authentic recordings. It just isn't necessarily reliable in terms of, you know, what it purports to portray.
Correct. But I want to be careful about this. Again, you can get compilation videos, and it's very seductive to go, okay, that seems accurate. No, it's not. Get the images originally recorded and go through them. Evidence that turns on phrases and spelling. So, you know, let's say we're talking about electronic communications.
Oh, okay? That's always very tricky, actually. The way people text, you're talking about, because there's all shorthand.
This is really important.
Shorthand and typos and, like, you know, all kinds of stuff. Where it's just like, that's why it's like people say it's better to talk in person, because when you're texting, it's like you can't get emotion conveyed, and you don't know if somebody's necessarily laughing. They can, and sometimes they'll put LMAO, but you know, it's like it's sarcastic or whatever. It's like, right. So yeah, like, yeah, exactly what you're saying.
Turns of phrases, spelling. You know, I'm not really this cool when it comes to how people communicate on messages. Like, there's all this language that's out there on, I don't even know what it, Max, what is it, like Instagram? Is that still stuff like you communicate over Insta and you've got handles and you've got ways you phrase shit, and I don't even know what the hell it is.
There's all these acronyms and like...
Yeah, who knows what all this means? So you can attack, what is the meaning? What is the weight of this evidence depending upon how this is written?
Yeah.
That is a very, very effective way of challenging that type of communication. And the grammar, spelling, or the invocation of a particular emotion is not necessarily unique to a particular person. In other words, it could be quite ambiguous. If you have communications that doesn't specifically identify the person who's authoring it or receiving it and sending it out, it may be quite innocuous. You might not be able to determine who is really who.
What is that thing people use? I've never used it before because it's so annoying, but where autocorrect or something?
Yeah,
it's like you can be typing something.
Well, I have autocorrect.
It is this craziness for me. It's like, because it predicts what it thinks you're going to say. But it replaces stuff.
Right. So but that's important. It will replace a word with something else. But let's talk about other apps. There are many other apps that are, you know, geared towards secrecy, right? So,
right, Snapchat is a big problem because it deletes things randomly sometimes.
Well, we had this in another case. So there's like apps like Signal and what are the other ones? So they're encrypted applications, and in those applications, you're not necessarily able to identify the sender.
But
right?
also it just randomly deletes certain ones. Like sometimes you can choose to save certain types of things, but I don't know. It's just like we've had ones where they have some messages and then there's other ones missing and they can't recover them
So
all because
you lose the context.
It has an auto delete function on it.
Right, but let's think about the encrypted apps where you're not able to identify who the sender is. But the person who's trying to tender the message will say, that's from, Bob.
Well, yeah.
But there's no direct evidence that it's actually Bob.
You can actually create another account and message yourself and put a name on that other message or like put a name to it.
So look at
the person.
So look at the language and what is being described in the language, because that may be not indicative of whoever you're saying is the sender. So these are important ways of thinking about...
If you can attach it to an email address or a phone number, that's generally will help you authenticate it.
100%.
Yeah.
Right to an IP address.
Yeah.
But there are ways to try and challenge this. And more communications we're faced with are over these other types of applications. Mm-hmm. And so there are ways to deal with it, even though it can be authenticated and admissible. There are lots of ways to challenge this evidence. Mm-hmm. And it's an interesting field because it's growing and it's only getting more complex with artificial intelligence and with all sorts of other sophisticated communications. This is something that's going to, become more of an area to look at in the future.
And I think this is such an important topic for us to talk about because people do come in and they think that they have evidence this and evidence that, and they need, understanding what is evidence and how to authenticate things, I think is so important for people who find themselves facing allegations and then also getting disclosure and then finding out, well, how the heck are they allowed to use this? This isn't real. So I think it's such an important topic to help people kind of understand some of the nuances and the logic behind how this kind of works. And generally, like we've said, most things can be authenticated to some degree, but they may not be given a lot of weight depending on the quality of the recording.
Okay, I have one more thing to do. I'm sorry, am I running really long?
A little bit long.
What are we at now?
Almost an hour.
Me. I think this is a record. I'm so sorry because this is important. So just one other thing. So let's say somebody records a conversation. Typically you see this with the police in an operation where they want to get an accused surreptitiously to admit to a criminal offense, okay? Mm-hmm. But we face it also where we might have a client who has wanted to record a conversation with somebody who's complaining about something with them, and they want to get admission from the complainant.
Who's complaining.
Yeah. They want to get the complaining complainant to say something that's contrary to their narrative, right. Okay? Yeah. So let's say you have only, a 10-second or 20-second or 50-second or 2 minutes of what is a 45-minute conversation. Is that admissible? I'm putting you on the spot here.
10 seconds of a 42-minute conversation?
Is that admissible?
That would potentially be admissible, but it wouldn't be given a lot of weight.
So let me just state this, and then I know we're running long. I'm so sorry. So it's settled law, okay? And I'm relying on Regina versus Merritt, M-E-R-R-I-T-T. It is an Ontario Court of Appeal decision. McPherson, Pachaco, and Thornburn, 2023 was the judgment. It was amended March 30th, 2023. ONCA3, okay? Great case. So I just want to make sure we're clear. It's settled law that where a partial or incomplete statement is offered into evidence as a party admission. This is important because often this is run by the Crown as against an accused, but lacks sufficient context to give meaning to the words. That partial or incomplete statement is irrelevant and lacks probative value. It is therefore inadmissible. It follows that if a partially heard statement, in this case, proof of an incomplete statement, is admitted into evidence in a jury trial, and the jury determines that there is insufficient context to give meaning to the words, the jury must disregard the partial or incomplete statement. Let's just put this into simple understanding. Yeah. You have a partial recording, but because it's so partial, you can't apply context and meaning to what was actually said. Therefore, it can become inadmissible. And this is about a party admission. It's a slightly different standard when you're dealing about an accused making an admission in a criminal case versus what you may be recording about what a complainant is saying to you in a discussion. I just want to draw that distinction.
Yeah, I just wanted to give an example. Like imagine you had a recording of somebody just simply saying, I was there, but you have no idea what they were answering, right? Or where they were saying they were. right?
I didn't mean to do it.
Yeah, right.
I didn't mean to do what?
So if you have this, like these small little recordings, there's like, and then somebody could say, oh, that was the thing they said to me after I said whatever. And it's like, well, why didn't you record you asking that question first?
And this applies to, I just want to do this because
That's
this was
a good point.
It is, and I just want to do this because we had a sexual assault case a little while ago in Ottawa, and I'm not going to name anything else, but we had a witness who was testifying about what they overheard, okay? That's important because hearing something, you get some witness to say, oh, I heard this conversation and I heard snippets, and this is what, Bob said. Okay, I don't mean to pick on Bob today. Let's say Todd. Todd said the following. Well, if it's a snippet without the context, you can't attribute meaning to it. It may not be admissible. Even if it gets through the admissibility level, you can't attribute any weight to it. Got to be careful about that. That's a party admission. And that's very important because they always try and do that to an accused. I advocate and say it's a slightly different threshold when it's communications between an accused and the complainant. It's not quite the same. But that said, this is very important to pay attention to because in our cases, murder cases we've had it in, but particularly in sex assault cases, you may have, in often instances, a complainant. I'm a friend of the complainant. I heard them arguing. I heard him say the following. I witnessed him apologizing, and therefore this must mean that he was apologizing for beating her. No.
And so that's a really important difference because, like we said, you can authenticate documents, text messages, recordings. You can authenticate them through testimony, but you can't just testify to something and make it a document.
That's a fun way of putting it. All right, we've exhausted you guys. So we really thank you for bearing with us. I hope you found this useful. Thank you very much. Please don't forget to like, share, subscribe, comment, and send us those comments because that's what is the impetus for a lot of these things. So thank you and good night.
Absolutely.